Hi guys. So I do work for Bride and Swearingen in England, and I am a bankruptcy attorney. I do a variety of other stuff too, but you can look that up on our website afterwards and check out everything that we do as a firm and everything that I do personally. What I want to talk to you today about is collecting debts that are owed to you, because we all know that we're in business to make money, and sometimes we make bad decisions and people don't pay us the money that they should. So the first thing that I want you guys to know, okay, how do I work this? That's not the way. So does somebody want to help me with this? I don't know what I'm doing. Okay. The different bankruptcies that are available are 7, 9, 11, 12, 13, and 15. The two that we're going to talk about today are 7 and 13, because those are the ones that are available to consumers, the ones that are hopefully purchasing from you. The different bankruptcies, though, are Chapter 9 is for municipalities, 11 is for the larger debts or for the people like GM who are going bankrupt. Chapter 12 is for family, farmer, or fishermen, and Chapter 15 is for foreign entities. The main differences between Chapter 7 and Chapter 13 are that Chapter 7 lasts about 90 days from the day that they file until the day that they're discharged. And there's a 6-month review period from the day that they file. So, like, for instance, if somebody inherits money, then the trustee will go get that money and distribute it amongst the creditors, which are you guys, and we'll talk about how you get that money in a second. Chapter 7 also liquidates debts. And under state law, some people get to keep some of their assets. In a Chapter 13, it lasts 3 to 5 years. Those creditors are going to be made payments to through the Chapter 13 trustee. So they're going to make, the debtor is going to make payments on some of those debts, and they're going to get to keep all of their assets. What I talked about is they get to keep some of their assets, and by doing that, we call them exemptions, and you're going to find those in the Revised Statutes of Missouri, Section 513. And any of those assets that are left over, the trustee is going to end up taking, and they're going to end up distributing amongst all the creditors. So how do you get that distribution? Well, for instance, we have the Hello Kitty house, and let's pretend that that's worth $100,000. We all know that it's really worth more than that, but let's just pretend that it's only worth $100,000. So the owner of the Hello Kitty house owes $85,000 to a bank. Well, that's a secured debt that nobody's going to get to take away. Pursuant to Missouri statute, they have $15,000 in assets which they get to keep. So there's $0 that are going to be distributed to all the extra creditors. In our next scenario, we're going to call the Hello Kitty house $115,000, say that it's worth that much. We keep the same amount of debt, and we keep the same amount of exemptions because those exemptions never change. There's going to be a $15,000 amount that the trustee is going to distribute amongst the creditors. So they're going to go and take that house, and they're going to distribute that for you. How do you get this? Well, in a Chapter 7 bankruptcy, what's going to happen is they're going to go ahead and send you a notice, because you don't have to file the proof of claim ahead of time, but they're going to send you a notice, you're going to file that proof of claim, and you're going to make sure that you have the information like your proof of debt to file with that proof of claim. The proof of debt is going to be, for instance, itemized services, or it's going to be a contract that you have with these people. Then you're going to want to file it with the court, and everything's electronic, so you want to make sure somebody in your company is set up with the bankruptcy court. So, that's how you get that money. But the question is, how much do you get? Unfortunately, in Chapter 7, it's hard to tell. It depends on how much money, how many other unsecured creditors go ahead and say that they also are owed money, and how much money you have that's owed to you as a percentage that's overall. So the trustee is going to decide what that is, and the trustee is going to make sure that you have that certain percentage. And if Chapter 13, what you need to know is you have to file a proof of claim. Always, always file a proof of claim, because the way that it's different from the Chapter 7 is that they're going to make payments for 36 to 60 months. Okay, and you never know what's going to happen in the next 36 to 60 months. You don't know if they're going to inherit money from somebody. You don't know if they're going to win the lottery or if they're going to get a distribution from workers' comp claim. I just about made this mistake recently. About 5 years ago, I made a bad business decision. I took a case knowing that I was going to get paid or hoping that I was going to get paid and didn't get paid up front. My client ended up racking up thousands of dollars and never paid me. Well, a year ago, he filed for Chapter 13 bankruptcy. I got a notice that said that he was going to get, or that all the creditors were going to get a 0% distribution, which means that I wasn't going to get anything. Luckily enough, last January, I filed a proof of claim anyway. And it turns out 2 months ago, we found out he's going to get quite a bit of money from a workers' compensation claim. I'm going to get part of that money. In fact, a good portion of it, because I am one of 2 creditors who filed a proof of claim. So always, always, always file your proof of claim in a Chapter 13. You also need to know that when you're filing your proofs of claim, there are debts that are owed before they actually file versus debts after they file. Now, the debts before they file all need to be included in the proof of claim, and you can go ahead and get that from whoever that is. If they're after the proof of claim, then you can still collect on that. You can still get 100% of that from the person, okay? There are certain circumstances when you can't, but for the most part, you absolutely can still go ahead and collect on it. And make sure that they know that it's after the date, so that way you can't get in trouble for still trying to collect. There are also exceptions to discharge. And this is something that everybody needs to be aware of, because what has to happen in the exceptions to discharge is you actually have to file a lawsuit with the bankruptcy court. It's called an adversary hearing, and in Section 11 USC 523, there are actually 19 exceptions to discharge. What you need to be aware of are the two that are the big ones are the fraud and the luxury items. If someone has purchased a luxury item from you, like a hot tub or something, and you think that that was just for fun instead of for medicinal purposes, then maybe you can still get paid in full through the bankruptcy, or make sure that that's a non-dischargeable debt. The different bankruptcies, or the different exceptions to discharge, are certain taxes, some money, property, services obtained by false pretenses, false representation, and actual fraud. If you're a creditor that's not listed, your claim may not be discharged. Now, that doesn't mean that you weren't, just because you didn't get notice doesn't mean you weren't listed. It may just mean they have the wrong address. So check that out before you go ahead and assert this when you're trying to get paid. If there's any actual fraud while you're in a superior capacity, or there's embezzlement or larceny, then that's non-dischargeable. Child support or alimony and maintenance, willful or malicious injury, some government debts, and some government overpayments. Any debt that's from a death or personal injury caused while the person is intoxicated. Previous debts, either waived or denied discharge, certain judgments for depository institutions, some debts for federal depository institutions, payment for money owed for convictions of federal crimes, taxes to other governments, fines for penalties under election law. Vote for Pedro. And then this is my information. I do, if you guys are actually contemplating bankruptcy or have clients who have filed for bankruptcy, you have some questions, feel free to contact me at erinbridenlaw.com, and I'll answer your questions about that real quick and hopefully get you guys some answers, and hopefully you guys can get paid. There's our website if you guys want to know more about what our firm does and what we do. You guys can follow me on Twitter. I'm real exciting. Or Facebook. So, all right. Thanks.